Well, good afternoon, everyone, and welcome to the 2011 World Stem Cell Summit panel discussion on the NIH guidelines for human pluripotent stem cell research and the currently ongoing saga called Sherley v. Sebelius, which is federal litigation involving the guidelines. We have quite a distinguished panel here covering San Francisco, LA, and San Diego, so we really have California covered well. Each of the panelists that are here are quite distinguished. They are accomplished authors in this field, and I'm really quite honored and privileged to be able to share the panel with them. From San Francisco, we have Professor of Law Hank Greely. To my far left, in the middle, we have Professor Russell Korrobkin from UCLA Law School, and to my immediate left, we have Dr. Jeanne, who is the director of the Center for Regenerative Medicine at the Scripps Institute down in La Jolla. We're going to do this, we're going to have three parts. First, some formal comments from each of the panelists. Then we'll have a panel discussion, and during that panel discussion, we'll invite questions from the participants as well. Professor Korrobkin is going to speak about the NIH guidelines, the lead up to those guidelines, and some of the more important structural aspects of those guidelines. Professor Greely will speak about Sherley v. Sebelius, and Dr. Loring will give us a scientist's perspective on the real and perceived machinations of what all of this means. Just as a grounding slide, here's the current status of the HESC registry that was generated last week, and you can see that there are currently 135 human embryonic stem cells on the registry. 59 have been denied along the way. 35 are pending approval. They're ready to be considered, and 40 are in various stages of preparation. So that adds up to 269. I believe when the registry was first announced, there were estimates that there could be as many as, was it 700 lines? Was that the figure that Dr. Collins used? So without anything further said about this, I'm going to introduce Professor Korrobkin to talk about how this came about.
Well, I want to thank Alan for inviting me and organizing, and it's just quite an honor for me to be on a panel with Hank Greely and Jeanne Loring, so really pleased to be here. Alan asked me to talk about the NIH stem cell research guidelines, and I'm just going to talk, since my limited amount of time, I'm going to talk a little bit about some of the broader legal and policy issues that I think are sort of tied in with the guidelines. So I'm going to talk about sort of the guidelines from a procedural and then a substantive perspective. On the procedural side, one thing that, it's sort of been many years now, but I think it still bears explaining, because a lot of people still are not aware that the funding policy, the federal government's funding policy for embryonic stem cell research in the Bush years, which everyone here is fully aware of what that policy was, but not everyone understands where it came from or its legal justification. So it's important to know that what happens is that the Congress allocates money for scientific research to the NIH and to other departments and parts of the federal government, and then usually doesn't get into telling the particular agency how to give out the money. And when President Bush made his decision not to fund embryonic stem cell research except for the particular lines that were already created, there wasn't any legal authority in a strict sense from that. That was just Bush as the boss of the Secretary of Health and Human Services, who has oversight over the NIH, just telling his employees what to allocate money for and what not to allocate money for. So there was an executive order issued late in the Bush administration, but that didn't come till almost the end of the Bush administration. So when President Obama got elected in 2008, of course there was great excitement, I'm sure amongst everyone in this room, about the likelihood of a change in that policy. But there was a question about how to go about changing that policy, sort of what would the legal basis be. And in 2006 and 2007, Congress had passed a law called the Stem Cell Research Enhancement Act 2 times, vetoed both times by President Bush. But there were enough votes in both the House and the Senate to get it through both of those bodies, which would have given specific guidance that the Secretary of Health and Human Services was to utilize some portion of the money that the Secretary received for scientific research for embryonic stem cell research. That is, not to discriminate against human embryonic stem cell research in the allocation of grant money. And I think most of us thought that what would happen after President Obama was elected is that the Congress would again pass the Stem Cell Research Enhancement Act, and President Obama would sign it into law. But the Democratic leadership in Congress, along with President Obama, made a decision, and I can't say why they made this decision. I'm not sure anyone knows the reason, but the decision was made not to bring the Stem Cell Research Enhancement Act back for another vote, where it certainly had the votes to pass in 2009. Instead, it was decided that the rule would be changed merely by the issuance of an executive order by President Obama. So President Obama, in March 2009, issued the executive order saying that the government would now fund human embryonic stem cell research, and then asking the NIH to come up with some guidelines to implement that executive order. Now, as a result of this procedural choice on the part of the Democrats in Congress and the Obama administration, we've already seen one minor crisis. Some of you might think it was more than a minor crisis, at least a minor crisis, and we also have the risk of, I think, a potential tremendous catastrophe. So first of all, that decision made the Sherley versus Sebelius lawsuit possible. And I'm not going to talk about the specifics. I'm going to leave that to my friend and colleague Hank Greely to talk about the specific legislation. But the particular language at issue was language that's contained in the Dickey-Wicker Amendment that's included each year as part of the Congress's appropriations legislation that puts some limits on the funding of human embryonic stem cell research. If the Stem Cell Research Enhancement Act had been passed, then that legislation would have been very clear that the government would not have been precluded, and in fact would have been required to fund research using human embryonic stem cell lines. So the fact that there was an entire legal battle that still goes on to this day over whether the federal government may provide funding for this type of research so long as it doesn't provide funding for the actual derivation of the stem cell lines, that's an issue that never would have arisen if the government had taken the legislative route rather than the executive order route, and we wouldn't have had the injunction, the preliminary injunction that was granted by Judge Lamberth, and the at least short time cutoff of federal funding and the continuing uncertainty. Okay, so that's minor disaster number one. The major catastrophe is that also as a result of the executive order rather than a statute, rather than legislation being enacted, this means that just as President Obama, with a stroke of a pen, said that the government could now broaden its funding of human embryonic stem cell research, so can the next president, if he or she chooses, change the position of the federal government just as easily and just as quickly. And those of you that have been following the Republican primaries closely might have noticed that when the issue comes up, all of the candidates that are on the stage at the various Republican debates go running away from human embryonic stem cell research. And it seems as though, although nobody's really been pinned down on a lot of specifics, all the declared candidates for the Republican nomination appear to be taking the position that they would cut back on or eliminate funding for embryonic stem cell research. And it's become, I think, sort of a usual talking point of many of these candidates to talk about how much they favor adult stem cell research, and this is where all the discoveries have been that have led to new treatments. You've heard these arguments before. So I think that although this is not likely to be a major issue in the presidential campaign this year, and it might be one that President Obama raises as an issue because, as I think most of you are also aware of, polls pretty reliably show that somewhere between 55 and 65% of the public favors embryonic stem cell research. If one of the Republicans that's currently a declared candidate, at least, is elected president, there's a very good chance that he or she's going to be under a lot of pressure to reverse the Obama executive order and completely eliminate, or at least maybe cut back, sort of go back to the Bush-era policy for funding of embryonic stem cell research. This is also something that would have been avoided had Congress in 2009 passed the Stem Cell Research Enhancement Act, because then you would have all the barriers that make it difficult to get legislation through Congress would have prevented barriers to changing the rules at that point. That is, needing 60 votes in the Senate, for example, to get past, to get to the floor for an official vote. Okay, that's on the procedural side. So let me just talk for a couple minutes about the substantive side. So there are two portions of the executive order that I find troubling. One is that it contains the limitation that federal funding for human embryonic stem cell research can only be done for stem cell lines that were derived with embryos that were created for in vitro fertilization and were left over from that procedure. So that means that no funding available for not just for the creation of embryos for research purposes, but you can't even give federal funding for research on embryonic stem cell lines that were derived from embryos that were created specifically for research purposes. And also, by implication and also as a separately enumerated point in the guidelines, I believe, also no funding of research on lines that may in the future be produced through somatic cell nuclear transfer. This is based on, the reason for this restriction is based on what's sometimes called the discarded created distinction. That I have been in past in articles and in my book on stem cell research been quite critical of. The idea that it is somehow morally appropriate to use embryos that were created for the purpose of reproduction, but now are left over. It's morally acceptable to use those for research purposes because, of course, these embryos are going to be destroyed anyway. But at the same time, it's morally inappropriate to create new embryos specifically for research purposes. And the problem, I think, with this reasoning, although it certainly has a level of intuitive appeal to it, the problem, I think, is that it's very misleading, in my opinion, to say that embryos that are excess IVF embryos were actually created for reproductive purposes. The way I think about the issue is that when extra embryos are created, when more embryos are created for in vitro fertilization than can actually be used in a course of IVF treatment, I think it's misleading to say that they were created for reproductive purposes. The reason they're created is because it is convenient and cost-effective for someone who's going through IVF to create as many embryos as possible from one course of fertility treatment and then choose the ones that are most likely to survive to implant to try to create a baby. But if what you're really concerned about right? If what you're really concerned about is you believe that it's morally inappropriate to create embryos for any purpose other than reproduction, then it seems to me the logical requirement would be to allow IVF programs to only create the number of embryos that they're going to implant at that time. And in fact, this is the law. For example, just at lunch today, we were talking about how in Germany this is actually the law, that you can do in vitro fertilization, but you can only create the number of embryos that you're going to implant right at that time. You can't create 10 or 20 embryos, choose 2 or 3, and then discard the rest. So it seems to me that if we are going to allow the creation of embryos for IVF far in excess of what's necessary for IVF, there are very good reasons to do that. And I don't tell this story to suggest that I'm in any way critical of that at all. But if that's morally appropriate, then it doesn't seem to me to be a good way to draw the line between that and creating embryos for purposes of stem cell research. One point again about the Stem Cell Research Enhancement Act. If that act had been passed rather than going the executive order route, then this particular distinction between discarded and created embryos would have been the law. The Stem Cell Research Enhancement Act drew this distinction that I've just been critical of. But you might think of it as a requirement of that statute because of the political necessity, that if you want to get a majority of votes in Congress, sometimes you have to make political compromises. And if the Stem Cell Research Enhancement Act had been passed, we would have had this limitation, but we would have had more certainty about the future of federal funding that legislation would have provided, and that might have been a reasonable trade-off. But in some ways, as for those of us that are proponents of stem cell research, which I assume would be most of the people in this room, in some ways we have the worst of both worlds, that we don't have any stability of the legislation, yet what we have by means of executive order was written to include a limitation that is not strictly speaking, a logically well-defined limitation, but is one that's more of a political compromise. But if you're enacting an executive order, you don't have to make a political compromise in the way that you might have to make to get legislation enacted. Do I have time for one more point, Alan, or am I still? Okay. So the one other point I want to make about the substance of the guidelines. There's also the other substantive point that I take issue with is the prohibition on any compensation for the contribution of embryos. Now, as an empirical matter, and I'll let Jeanne comment on this later, I'm not sure, since I'm not a scientist, I'm not sure as an empirical matter whether this will be a major impediment to stem cell research, that if we're only going to be able to use embryos that are excess IVF embryos, that it seems likely to me that there will be enough people willing to contribute these embryos without compensation that it won't hinder scientific progress to have a rule that you can't provide any compensation for these embryos. On the other hand, I think it is possible that it could matter in the future, especially since the regulations don't allow funding for creating on any embryos that were created explicitly for research purposes. It might be that to try to derive stem cell lines with certain disease properties, it might be that researchers will want embryos that come from gamete donors with particular disease histories or genetic qualities. And in that case, it might be that we don't have this pool of many tens or hundreds of thousands of excess IVF embryos that would be relevant. It might be that certain researchers would be looking at a much more limited pool for potential donations to create embryonic stem cell lines in the future. And it might be that some of these we'd have a better ability to obtain for research purposes if there wasn't this prohibition on providing any compensation. The prohibition, I think, is based on, again, to me, a questionable philosophical position that offering any compensation for embryos, or we see this oftentimes in discussions over contributions of eggs, is in some way coercive, right? That is that people seeing the money, seeing the possibility of making money, will be driven to do things to make donations to science that they otherwise might not be willing to make and might not be in their best interest. This is another point that I've been quite critical about in writing in the past, is that by giving someone the option of making a donation and being able to use some amount of funding, and in this case it might well be used to finance part of the IVF treatment that they're actually getting, just opens up opportunities for people. And while there's no moral imperative, in my opinion, to pay people to make these kind of donations, if there are particular characteristics of embryos that are particularly required for scientific purposes, and if scientists are willing to spend their limited research dollars in part to provide compensation for these materials, there doesn't seem to me to be a good moral reason to prohibit it. And in fact, can offer a kind of win-win situation. In the United Kingdom, for example, it is legal to provide women who donate eggs for research purposes with a reduction in the cost of IVF treatment. So I think in particular, if women want to undergo IVF treatment, they can be given a discount if they'll allow half of the eggs that they generate to be used for research purposes. So it creates opportunities when the scientific need makes that necessary. The prohibition, in addition to having this problem of seeing coercion, where I am more inclined to see opportunities, it does create kind of a strange loophole in the rule that's at least worth pointing out, that women can be paid to provide eggs for IVF purposes, for reproductive purposes. Then the person who has paid a woman sometimes a fair bit of money for the egg donation, then if the person who's trying to create the baby has extra embryos left over, then they can apparently, under the guidelines, they can donate those embryos. And they're not getting paid, so they're not violating the federal guidelines. And then the embryonic stem cell lines that are then derived from those embryos can be eligible for federal funding. So we have a situation where it is quite possible that embryonic stem cell lines that will be eligible and listed in the federal registry, eligible for funding, will actually be created through paid egg donations, even though there can't be a direct payment on the research end. And so again, if there is a sort of moral basis for making sure that we're not using federal funds to fund any research that is the result of paid gamete or embryo donations, then this loophole to me kind of undermines the existence of that distinction. Okay, I'm going to stop and turn it over to the next panel member.
So in August of 2010, about 57 weeks ago, a federal judge named Royce Lamberth ordered the NIH to stop funding all human embryonic stem cell research. How many of you remember that moment? How many of you were tearing your hair out as a result of hearing about that moment? My assignment in the next 9 minutes is to bring you up to date on that case and tell you where I think it's heading. To do that, I want to talk a little bit about the history of the case. I want to talk about the arguments in the case, and I want to talk about the future of the case. 9 minutes isn't a lot of time, so to make sure I get to it, I will start with my bottom line. Be happy, don't worry. Very much. So, in a sense, I think you can date the history of this case back to 1994, when HHS got a report from a committee it had appointed, a human embryonic research panel, that was appointed at the request of the administration, the Clinton administration, to consider whether the federal government should fund research on human embryos. And it said, pretty much yes. At least for a bunch of reasons, yes. For other purposes, no. President Clinton received them. He was happy. He said, great, and immediately said, and I like all of it except for this one part about creating embryos specifically for research. That got embryo research issues on the map in a big way. And 2 years later, in 1996, two members of Congress, Dickey and Wicker, invented the Dickey-Wicker Amendment. The Dickey-Wicker Amendment was a rider to the HHS appropriations bill. Appropriations bills have to be passed every year, or more likely they don't get passed and it gets rolled into a continuing resolution that gets passed every year when Congress doesn't get its act together, which is frequently. But every year since 1996, the Dickey-Wicker language, with only minor modifications, has been put into the appropriations bill for HHS. And it says, no money appropriated under this bill shall be used for some things, including research that destroys or puts at risk human embryos. 2 years after the first unveiling of Dickey-Wicker, Jamie Thompson announced the discovery, the isolation and purification of human embryonic stem cells. The Clinton administration then had to figure out, what can we do under Dickey-Wicker? And Harriet Rabb, who was the general counsel of HHS, issued an opinion saying, it doesn't stop us from funding research done on embryonic stem cell lines where somebody else destroyed the embryo. If we're not paying for the actual destruction of the embryo, we're just paying for research done with cell lines that were created by somebody else destroying the embryo, then we are not paying for research in which embryos are destroyed. That was the argument. It's a plausible argument. As a lawyer, I kind of like it. It's a good legalistic argument. I doubt that it corresponds with the spirit of Messrs. Dickey and Wicker, but that's what lawyers do. We find things where the letter of the law is inconsistent with the spirit of the law, and we argue whichever direction helps our client best. So that was the Clinton position, the Clinton administration position. President Bush comes into office, and we all remember, I'm sure, August 9th, 2001, when from his ranch in Texas, he announces a new policy on stem cell research. We're not going to do it hardly at all. But he was still going to fund some of it, which meant his administration was accepting the same interpretation of Dickey-Wicker, that they were allowed to fund research on previously created embryonic stem cell lines as long as they weren't paying for the destruction or the risking of embryos. The Bush administration comes, the Bush administration goes, the Obama administration comes in. In July of 2009, after an executive order, NIH puts out guidelines. Here's how we're going to fund embryonic stem cell research, the guidelines Russ talked about, expanding beyond what President Bush had allowed. And once again, they adopt the same interpretation of Dickey-Wicker. It allows us to fund research with embryonic stem cell lines that came about because of the destruction of embryos, as long as we didn't pay for the destruction of embryos. 3 administrations, 2 political parties. I think now 15 Congresses have passed Dickey-Wicker, all with the same interpretation. In August of 2009, a month after the NIH guidelines, a lawsuit is filed. The lawsuit is filed by a variety of entities, 2 couples who have frozen embryos for reproductive purposes, the Christian Medical Association, the Christian Nightlight Adoption Agency, certain unnamed embryos suing on their own respect, and 2 researchers, Sherley and Dreiser. It gets assigned to Judge Royce Lamberth. Judge Lamberth is a judge in the district court, the federal court for the District of Columbia. He is originally from Texas. I don't think anyone disputes that he is a bright man. Very few people also would dispute that he is a quirky judge with a certain degree of, shall we say, determination, which is the nice way to say stubbornness. Judge Lamberth originally decided that this case had to go away. He threw it out on the grounds that none of the plaintiffs had standing. Standing is one of those great legal words that A, doesn't sound like it means anything, and B, the more you understand it, the more you understand that it actually doesn't mean anything, or that there is no good way to explain what it means. The theory behind standing is somebody who brings a lawsuit has to have some real stake in it. You can't just go around and say, hey, I think that law is bad. I'm going to sue to have it enjoined. You got to have some real reason for it, and we hook this into the Constitution because the Constitution gives federal courts jurisdiction over cases and controversies. And the courts have said, well, if there's no standing, if you don't really have a dog in the fight, there's no case or controversy, and we don't have any jurisdiction. So he said, no standing for any of these guys. They've got no real complaint here. The embryos aren't people, and the rest of them aren't having anything of theirs destroyed or harmed, and no standing. Go away. Don't bother me. They appeal that to the District of Columbia Circuit Court, the D.C. Circuit, which in June of 2010 reverses and says, well, you know, for the embryos, for the Christian Medical Association, for the couples, they didn't even appeal standing. There's no standing. There's no standing there. But these two researchers, they said they work on adult cell lines, and because the NIH is going to fund embryonic cell line research, there's less money for them to get. And they are harmed by all of the money and time and effort they put into writing grant applications and rewriting grant applications that they're not going to get because of all this money going off for embryonic stem cell research. I think that's a bad decision. I said that at the time. I was quoted in Nature saying that at the time, and I still think that's right. It's not a dramatically bad decision, and it's not a very important decision, I said, because, yeah, they've got standing, but the judge is now going to throw their lawsuit out on the merits. I was wrong about that part. The case went back to Judge Lamberth, who responded to a motion they had made earlier for a preliminary injunction without holding new briefing, without having an argument with the lawyers from both sides to talk about it. Judge Lamberth, kind of out of the blue, in August, late August last year, issued an injunction telling NIH, HHS, you can't spend money on this. This is, I think, partially evidence of his quirkiness, that he didn't hold oral argument, that he didn't get briefing. He apparently didn't actually realize that he was also effectively invalidating the Bush administration policy as well. He just put it out there. The good news was it quickly got stayed. So you pulled your hair out, and then a few weeks later you learned that the upper court was not going to let the injunction take effect until it had been appealed, until the appeal had been heard. Now, a preliminary injunction is a legal thing that doesn't decide the merits. It just says, while this suit is going on, until we decide who wins, I'm going to keep things from changing. I'm going to hold everything where it is until I decide the merits. That's what Judge Lamberth issued. He said he did it. In order to issue it, he had to find that the plaintiffs were likely to win. The defendants appealed that to the D.C. Circuit, a different set of 3 judges by a 2-to-1 vote. Earlier this year said Judge Lamberth was wrong. The preliminary injunction has to be reversed. These plaintiffs are not likely to win. In fact, they're likely to lose, at least on this argument. The preliminary injunction then disappeared. The case didn't. Without the preliminary injunction, the funding could go forward, but the case still had to be tried as to whether or not, it still had to be decided as to whether or not Dickey Wicker was violated by this policy. Both sides asked for what's called summary judgment, which is a way of deciding an issue before there's a trial, when the facts aren't in dispute. And Judge Lamberth, I think to his credit, issued summary judgment for the government. He did it in a sort of half-gracious way, basically making it clear he still thought he was right and the Court of Appeals was wrong, but he remembered that they were his boss and he didn't have any choice. He had to go ahead and grant summary judgment. Now, he didn't necessarily have to grant summary judgment. The plaintiffs had about 5 arguments, and only one had been involved in the preliminary injunction. So the D.C. Circuit had only ruled on one of those arguments, granted the least bad argument. Judge Lamberth then went through the next 4 arguments and decided all of those against the plaintiffs, issued summary judgment. 2 weeks ago, the plaintiffs filed their notice of appeal. That's where we are right now. What are the arguments? The main argument for the plaintiffs is that the word research in Dickey Wicker doesn't just mean exactly what the research applicants, the grant applicants have written they intend to do with their money, but the whole gamish, the whole set of research, the whole research enterprise that includes what they're doing. And that embryos were destroyed in the stem cell research, even though these particular grantees aren't planning to destroy any embryos or put them at risk. Now, language in reading statutes is really tricky. Words are very ambiguous. Sometimes they're ambiguous accidentally. Sometimes lawyers and legislators intentionally make them ambiguous. Some are born ambiguous, some become ambiguous, and some have ambiguity thrust upon them. If a word in a statute is ambiguous, the courts say we give a preference to the agency that's supposed to interpret it. If they come up with a reasonable interpretation of an ambiguous term, well, we'll use it. And the government said, hey, research is at least ambiguous here. The Clinton administration, the Bush administration, the Obama administration, a bunch of secretaries of HHS have all interpreted it to mean we can do this. And furthermore, 15 times Congress has reenacted this language, each time knowing that the administration thinks it means they can do this. If Congress thought it didn't mean that, they should have changed the language. Pretty good argument. I frankly think a slam dunk argument. Judge Lamberth disagreed. He said, research isn't ambiguous. Its use here is completely unambiguous. It means looking for discoveries, looking for, trying to find generalizable knowledge, and in that sense, embryos are destroyed in this research. Unambiguously, clearly, clear as mud. D.C. Circuit said, looks ambiguous to us. And here's some reasons. Here's one thing it could mean. Here's another thing it could mean. The agency's interpretation wins. Now, the D.C. Circuit did that in the context of deciding whether the plaintiffs were likely to win on the merits. They weren't saying plaintiffs lose, plaintiffs win. This is in the preliminary injunction. Now it's being appealed after the summary judgment. So now we move to the future. What's going to happen? I think the plaintiffs are going to lose again. The plaintiffs should lose. They've got a bad argument. They've got a bad argument on that. They've got several other bad arguments, several other worse arguments. The only one that's kind of interesting is the one that says, well, by doing this research, you'll make embryonic stem cells more useful, you'll save people's lives, and therefore more embryos will be killed in the future to make more. And that's a slightly different argument. Judge Lamberth himself had no difficulty rejecting it on summary judgment. I don't think that's a winner either. Specifically what happens is sometime in the next few weeks, a briefing schedule is set. And the parties are told when they have to get their briefs in. My guess is all the briefing will be done probably in late December, early January. Then the court, a panel of 3, probably I think the same 3 judges who ruled on the preliminary injunction, which is a very bad sign for the plaintiffs, will hold an oral argument on this case. That I think will happen March, April, May, something like that. And then some months later, they will issue an opinion. And the plaintiffs will lose again. I think the plaintiffs will lose because they should lose, because the government's argument is, as a legal matter, a much better argument. Research in this context is at the very least ambiguous. If it's unambiguous, I think it's unambiguous in the government's direction. Research in this context is what the researcher tells the NIH it wants the NIH's money to do. So I think they should lose. I also think they will lose because in the preliminary injunction case, the 3 judges who ruled 2-1 against the plaintiffs were all conservative. They were 3 Republican appointees, all relatively conservative, and 2 of them ruled in favor of the government. The D.C. Circuit has 5 relatively liberal judges, 5 relatively conservative judges. You've already got 2 of the conservative judges on the government side. I think they'll lose. What happens then? They have the chance to appeal to the Supreme Court. The Supreme Court gets about 8,000 cases a year where somebody says, please, 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 listen to my case and reverse the lower court. They listen to 80 cases a year. So you've got a 1% chance of getting listened to. Your chances go up if there's a fight between 2 different appellate courts, if the D.C. Circuit and the 9th Circuit and the 8th Circuit all have different views. It's called a circuit split. If that's the case, the only way to get unanimity, to get a uniform law in the country, is to have the Supreme Court, which bosses all of them around, say, no, this is the answer. There is no circuit split here. The D.C. Circuit is the only circuit that's ruled on it or is likely to rule on it. Sometimes the court is more willing to take cases if they involve the Constitution and something that Congress can't just easily change. This one is easily changed by Congress. It has to be reenacted every single year by Congress. That's another reason the court might be reluctant to take it. And finally, all other things being equal, the court actually doesn't really like to be in the middle of intensely controversial issues that are going to make people mad at it. If they don't have to take this case, I don't think they will. It takes the affirmative votes of 4 of the 9 members of the Supreme Court to hear a case. I don't think they'll take this case. So I think this case is going to die. I think we will get another circuit opinion affirming the dismissal of this probably next summer. And I think the Supreme Court will deny certiorari, which is our fancy term for say we're not going to hear it, probably sometime late fall, early winter of next year. And at that point, we can all heave a sigh of relief. Now, predicting the future of litigation is easy to do. It's just hard to be right at. And I would never say anything in law is 100% certain. I would never even say it's 98% certain. But I think this one's at least 95% certain. This case should die. I think we will look back on it as a strange and sad brief interlude, and we will move forward without having to worry about Dickie Wicker, unless Congress does something new. We may have to worry about other things. We may have to worry about a new president. We may have to worry about new congressional action. This issue, though, should be at rest. So don't worry, be happy, pretty much. Last point. In the long run, though, stem cell research funding from the federal government depends on political support. And the people who are opposed to it aren't going away. Their concerns, their issues, their moral and political commitments aren't going away. The people who are in favor of it are in favor of it because they expect cures. Most of the people who are in favor of it. If cures don't come, one side's interest doesn't disappear, the other side's interest diminishes. Political support for this research is dependent on progress in turning the research into useful medical breakthroughs or useful medical steps to relieve human suffering. And until human embryonic stem cell research achieves that, whatever happens in Sherley versus Sebelius, its legal and political future remains somewhat up in the air. Thanks.
Not easily. Okay, good. So, meanwhile, back in the lab, I'm going to tell you much of the same kinds of things that you've already heard from Hank and Russell, from a slightly different perspective. The scientists were aware that this is going on, but I think there was a lot of misperception about what the impact would be on us as researchers. So I'm going to give you a history of embryonic stem cell research in one slide with the high points. We should keep in mind that embryonic stem cells didn't emerge in 1998. Embryonic stem cells already existed in 1981. They happened to be mouse embryonic stem cells. But the same methods were used to make rhesus monkey embryonic stem cells and then human embryonic stem cells quite a few years later. So these are some of the highlights as far as I was concerned, and I think many of my colleagues. Both of the mouse ES cells and the rhesus monkey ES cell projects were funded by the NIH. And there's some interesting implications of that, which I can leave to my lawyer friends. The 1998 human embryonic stem cell derivation, however, could not be funded by the NIH because the NIH would not fund derivation or destroying embryos for making embryonic stem cells. So Geron funded it. In 1998, two things happened. The paper came out on human ES cells, and a patent was issued to Wharf, which gave them freedom to operate with human embryonic stem cells. And they were able to keep everyone else out of the market if they wished. So now comes 2001, and George Bush has finally, for the first time, allowed research on embryonic stem cells to go forward under the NIH funding regulations. It was an interesting decision. I think a lot of us were confused by it, but really when we look back on it, he was the president who actually had the nerve to stand up and in a statement, as they said, not an executive order, but a statement, he told the NIH that they were to start funding embryonic stem cell research on lines that had already been derived. Also that year, the second one of the Wharf patents on embryonic stem cells was issued. Okay, so in the middle here are the amounts in millions of dollars that the NIH spent on human embryonic stem cell research. And you'll notice it went from 0 in 2001 and began to pick up in 2002. So in 2002, the NIH obeyed the order from their president, and they started to solicit grants from all of the people who had made embryonic stem cells. Now, one of the interesting things about this is that most of the embryonic stem cell lines had been made outside the United States, and most of them had been made by for-profit organizations, which made the funding, they had to get very creative with their funding at the NIH, because these are unconventional applicants, many of whom had never written a grant before. But they did fund research in order for us to take the cells out of the freezer and grow them up and see whether we can make real lines out of them. And interestingly, the original registry had 78 derivations on it. They were called derivations, not lines. Luckily, I had 9 of those derivations myself on that list. In 2003, the NIH started a human embryonic stem cell training programs, which were really essential because there was only a handful of people who knew how to grow embryonic stem cells, and it was necessary to teach more people so that the NIH could fund more research. But by 2004, the NIH registry had decreased to 21 embryonic stem cell lines. And the reason for this was that most of those derivations never even survived the freezer. Many of these derivations were simply embryos that had been frozen. They were intended to be made into embryonic stem cells and had been frozen, but they were called derivations. And this was because the Bush administration was really desperate to gather as many lines as possible in their list. So after 2 years and a great deal, not a great deal, but a fair amount of money spent on trying to grow these cells, we found that there were only 21 that were viable. And of course, in 2004 was when Prop 71 was passed in California. And for those of us who live here, everything changed. So 2006, as you've heard, the Stem Cell Research and Enhancement Act, which would have made the stem cell research funding by the NIH law, was vetoed by Bush. And in 2006, also, the NIH set up a contract to Wharf, who also holds the patents, for a national stem cell bank, providing them with $16 million to culture as many of those 21 lines as they could get and distribute them to researchers. Also in 2006, the Wharf patents were challenged in the patent office. 2007, Bush actually did release an executive order. This was an order that NIH was directed to fund ethical embryonic stem cell research, which was extremely complex and required addition of a knockout of certain genes so the cells couldn't actually become a human. But that was the way around of trying to allow people to make more cell lines, but cell lines that wouldn't be controversial. But that same year, he also vetoed the Stem Cell Research Enhancement Act one more time. So also in 2007, the Whorf patent claims were narrowed because of the challenge. And luckily, because in that same year, embryonic stem cells had a mate, induced pluripotent stem cells that were also pluripotent. The patent claims were narrowed so that they covered only embryonic stem cells and not induced pluripotent stem cells. I think that was an important change in the patent. 2009, now we have a new president. Obama issued an executive order to change eligibility of embryonic stem cells. And the result of that is the NIH registry was expanded, but in an interesting way. which I'll mention in a minute. 2010, the lawsuit, which you've heard about, it temporarily blocked NIH embryonic stem cell funding. Those of us who lived in California has had virtually no impact on us. In fact, it had virtually no impact on very many of the people in the U.S. It did, however, have a great impact on the NIH scientists themselves, the people who were on the NIH campus. They were ordered to destroy all of their human embryonic stem cell cultures on, I believe, August 24th, the day after the injunction was set out. And I visited the NIH on September 1st and heard a lot of real horror stories about they had no idea why they were supposed to destroy them, but obviously since they actually can control the NIH as a government agency, they had to follow the injunction. So they had to toss out their cultures and their experiments, etc. But that didn't happen very much otherwise. And also that year, the National Stem Cell Bank contract expired, and it hasn't been replaced with anything else. So far we have no central source of embryonic stem cells. Okay, so 2011, the injunction was lifted, but what lies ahead from what we've just heard? The uncertainty may affect the way we feel, but it probably won't have any impact on research progress long term. I think the only negative impact might be on particularly savvy graduate students who think that once the legal system becomes involved in their research, they really want to work on something else. The registry, as of now, has 135 embryonic stem cell lines. Only 7 of these are the original 21, from the original 21 that survived the first registry. So there are 2 questions. There's one comment and one question. The comment is that Obama actually, the other lines, the 14 lines that weren't approved, were not approved because Obama actually strengthened the ethical requirements for the cell lines. So he did expand them, but he obviously also made it much more difficult for people who didn't have their paperwork in order and the provenance of cells was not known to be able to get those cells approved by the NIH. And then the question which I'd like to leave you with is we have 135 embryonic stem cells on the registry. Those are eligible for NIH funding. There are at least another 400 embryonic stem cell lines that people have either not bothered to put on the registry or are just keeping them to themselves. A lot of those are in foreign countries. So the question is, how many embryonic stem cell lines do we really need? We did really well for about 9 years, 10 years, with the very limited number that we had. In fact, I don't think there's anyone who used all 21 lines. Practically everyone was limited to 2 lines, the Whorf lines. So the question is, will these 135 lines actually be used, and is there really anything to worry about for the future? Do we really need more embryonic stem cell lines? So that's what I wanted to leave you with, and it's something I think that my lawyer colleagues really don't think about because they don't spend a lot of time in the lab, although I think at least one of them, I think, is going to come and visit my lab, and maybe I'll teach them a thing or two. Thank you.
Thank you all. We have time for a few questions. We end at 5. One of the questions that I think all of the panelists touched upon, and Dr. Loring in particular, by her reference to international. I just have to figure out how to open up the laptop. There we go. No problem. And one of the questions that arises here is where NIH stands. And if for those of you who heard Dr. Trounsden present this morning, CERM has certainly taken a lead around the world. And this is what you see up on the board, and I don't know if you can see that in the back. You see statistics recently generated off the PubMed database using that search in the lower left-hand corner. This is very preliminary work. You can see from the first two rows that there are some discrepancies in the computation here, but more or less I think this is a good first approximation. And what you see is that the U.S. from January 2010 to just a few months ago went from 33.5% of all papers being produced down to 29%. You see China holding constant at 10%. I've done a little bit of a survey today asking people who they thought the country in the second position would be, and no one guessed this. So with that said, I know Dr. Loring has some thoughts on this, and I would ask you to. We had discussed this point, and I think you had some thoughts on this. Yeah.
Absolutely.
So.
Do you want me to?
Sure.
Ooh, sorry.
Yeah.
Okay. So a lot of us have. I mean, thanks to CERM, for example, a lot of us actually have collaborators in places like China and Germany and Australia, which is a ways down the list. China, in particular, has put a great deal of effort into embryonic stem cell research, and I think they have some challenges because of the difference in the way that they perceive science in general, the way they're trained. But in fact, I think they're doing some really very good work, and this is an example, I think, of what how investment in research drives research. We really can't do anything without money, and if you get enough money, then we can do a lot of things. And China is an example of a country that's decided to invest in this for the future.
Thank you. In terms of the comparison of human embryonic stem cells and induced pluripotent stem cells and the uncertainty that has existed as Sherley v. Sebelius has wound through its machinations, I'm wondering what is the current feeling about that debate?
I think you should take a survey. My current feeling, I think I've been very clear about that, and I have evidence to show it, so that always helps if you're a scientist, that iPS cells and ES cells are both quite variable, but that the variability overlaps. So embryonic stem cells and iPS cells are functionally equivalent. We may find, it's an interesting idea because the gold standard is really a historic standard. We think the gold standard is embryonic stem cells, but it could be that the iPS cells end up eventually being the gold standard and ES cells being the cell line that we're comparing it to. We really have no knowledge since we haven't done human trials with these two cell types.
If there are any questions from the participants, sure, go ahead.
Also give us how you arrived at that answer. What are the key factors that lead you to whatever conclusion you come up with?
So let's see, what was the question I left you with?
How many are needed?
Right, how many are needed? I think I'm going to be very practical here because the fact is with limited resources, and none of us has infinite resources, and I can't imagine very many labs culturing 135 cell lines. So how do we make a choice about which cell line to use? The way we do that is we either use the cell line we've always used if we're experienced, or we use the cell line that was made at our institution if we're not. So probably in the next 5 years, I would predict that maybe 30 cell lines will actually get some research done on them, but not a lot more than that. There are certain kinds of research you can do on very large groups of cells, like molecular analysis. We've done analysis on 500 embryonic stem cell lines, but that's quite different from culturing them all and taking care of them all. So I can't answer it. I think it depends on where the research goes, but I can't, I don't like particularly the lines that we've been using over and over again, and we have some very good lines that we're using instead, but we don't know if they're the best lines, and I don't know if we'll ever find out.
Go ahead.
I have a quick question. I'm going to inject a dose of capitalism, and I'll address the lawyers for that. So all of the approved cell lines approved for NIH funding, I believe you have to sign a license giving WRF and Y-cell intellectual property rights. So in terms of investment in stem cell research, I think that that's a big, huge barrier. And I'm wondering if the lawyers have thought of an antitrust suit against WRF with the U.S. government as the co-conspirator.
Want to address antitrust?
Did you practice law?
Not long enough to become an antitrust.
I practiced law for 4.5 years here in L.A., actually. Lived in Pasadena and was a general civil litigator. And the most important thing I learned as a litigator was that the best advice you can give clients is avoid litigation whenever possible. Ambrose Bierce defined it in the Devil's Dictionary as a noun. Machine you go into as a pig and come out of as a sausage. I think in this case, the chances of a successful antitrust suit are very low. There is a real conflict built into the nature of our law between the patent laws, which intentionally give people monopolies, and the antitrust laws, which try to ban monopolies. Those two laws have both been around for over 100 years. Their intersection is complicated. It is possible for patent holders to violate the antitrust laws, but things that non-patent holders would do to violate the antitrust laws, the ownership of a patent can help you with. So I think, actually I still am licensed to practice in this jurisdiction, but I'm not giving you legal advice here. My academic advice is I think that kind of a suit would have a very low probability of success.
Really,
I can't practice at all.
the problem...
I don't know.
The problem here is not an antitrust problem. It's a patent problem, and so patents were granted to WRF for human embryonic stem cells, as you know. This is a nice opportunity to plug my book here. So I have a chapter in my book. It's called Stem Cell Century.
Speaking of capitalism, you
right?
plug
Yeah,
your book?
it was the question was brought up about.
You should hold it up like.
So I do have a chapter on the WRF patents, and there we go. Look at that.
It is paperback.
I want to cut.
It is paperback.
I have a chapter on the WRF patents, and I think that, and they were challenged, as Jeanne mentioned briefly, and Jeanne was one of the movers in that challenge. And I think Jeanne was right that these patents should not have been granted, and there are a number of sort of very technical legal reasons. And I've always been a supporter of the view that for something like stem cells, you should be able to get a method patent. So you should be able to patent a way of doing things, but not be able to patent the raw materials themselves, not say we own embryonic stem cells and therefore anyone that wants to use embryonic stem cells has to pay us a license. Unfortunately, the position Jeanne and I took was not the prevailing position. So that's why you have to agree to the license terms in order to use the cells.
The only comment that I
have
would
not yet agreed.
The only comment I would add there is that, Hatch-Waxman, which was passed in 1984, which led to generic drugs, we're finally, how many years later, at the point where we're going to have follow-on biologics. Your question conjures all sorts of questions as to how would stem cell therapies be treated under a stem cell, I'm making up a term here on the fly, stem cell generics. It's an interesting question that you pose.
I would note, though, that one of the nice things about patents is they do expire. And the very first WRF patent should be expiring in a couple of years.
98.
98, so it's 17, that's still probably under the 17 years from date of issuance, so 2015?
So I'm not a lawyer, and I don't practice law, but I'm interested in talking about it, and I'm not going to lose my job if I say something wrong about the law, right?
I hope I won't either.
So obviously I thought the patents were much too broad, and they were impinging on people's freedom to operate, especially in for-profit organizations, but ultimately for all of us. And I just wanted to bring up one other very unlikely scenario, and that is that the 1998 patent, which is on all primate embryonic stem cells and covers human embryonic stem cells, that work was funded by the NIH, and that means that the NIH theoretically has march-in rights. If they wanted to take over that patent, then they could. They've never have, but this might be their first chance.
Jeff, did you have a question?
Sorry, but it's getting late. Russell, you said something that kind of triggered a thought, and I just wanted to bounce it off you. I mean, the idea that you could revert back to a Bush-like policy. It seems, if say, a Republican candidate chose to do that in the scenario you laid out, it seems like one very sort of politically expedient way to do that without a lot of collateral damage would be to sort of pull out the playbook from the fetal tissue experience, which would simply be don't do anything but don't allow the funding for the committee to operate. So it would just sort of freeze the registry where it is at this point in time, which would be like the Bush policy, and you wouldn't have had to have done much at all.
That's actually what Secretary of Harris did in 1980. In September 1980, Patricia Harris allowed the EAB to go out of existence, and as a result, in vitro fertilization work couldn't be funded by the NIH. That's exactly what she did in 1980, 2 months before the presidential election of that year. Next question, please.
Russ raised an interesting political question, which was why didn't the administration seek to pass legislation? I asked a number of friends in Washington, and I got an explanation. I wonder if anybody else got an explanation, which was that Senator Specter did not want it because he wanted an immediate addition to the stimulus bill, and he didn't want it to be held up, the NIH addition to the stimulus bill, on stem cell grounds. So do it by executive order so that we can add the NIH bump. I don't know if that's true, whether it had anything to do with Specter's perceived issues with his reelection and renomination and reelection, or whether that's just made up out of clear fantasy, but at least it's an explanation.
It sounds like quite a plausible one. Of course, that doesn't explain why, after the executive order was signed, there was still a 2-year period, right, before the next elections, which brought in the Republican majority in the House. So now you can't get it passed. But so your explanation might explain why they did the executive order, but wouldn't explain why they didn't then bring the bill to the floor for passage sometime within the 2-year period. And your guess is as good as mine about that.
You're talking about the fall of 2010? Is that the bit? Okay, because there was one other, fall of 2009. There were a lot of things going on, particularly with respect to economics at that point, that just, we were told, and the health care bill, we actually met with congressional leaders, and we were told that there was just way beyond one senator. There was just absolutely no appetite to take up this issue. Any other questions? I want to thank all the panelists. Thank you.